the federal law that could make machine guns legal again, and why two judges just shocked everyone. Something extraordinary just happened in a federal courthouse that could completely change everything you thought you knew about gun laws in America. Two of the most influential judges in the country just dropped a legal bombshell that has the entire firearms community buzzing, and the implications are staggering. What if I told you that one of the most restrictive gun laws in American history might have been illegal this entire time? Not because of the Second Amendment, but because of something far more fundamental that goes to the very heart of how our government works. This isn't some conspiracy theory. This is coming from judges who could potentially sit on the Supreme Court. The story begins with a murder case that seemed routine on the surface. Jamayan Wilson shot and killed a man who sold him a fake gun. During the investigation, authorities discovered Wilson had converted a handgun into a fully automatic weapon. Among the charges he faced was possession of an illegal machine gun, a violation that carries serious federal prison time. But here's where things get interesting. When Wilson's lawyers challenged his conviction, they stumbled upon something that legal scholars have been whispering about for decades, something that even a current Supreme Court justice flagged years ago, but that most people ignored. Until now. Judge James Ho and Judge Don Willett of the Fifth Circuit Court of Appeals, both potential future Supreme Court nominees, just issued opinions that sent shockwaves through the legal community. They didn't just question the machine gun ban, they suggested the entire law might be constitutionally invalid, and not for the reasons you'd expect. To understand why this matters, we need to go back to 1986. That year, Congress passed what's known as the Hughes Amendment, which made it illegal for civilians to own any machine gun manufactured after May 19, 1986. If you wanted a fully automatic weapon, you could only buy one made before that date, and you had to jump through extensive federal hoops to do it. For nearly 4 decades, this law has been considered untouchable. Gun rights advocates have tried countless times to challenge it on Second Amendment grounds, arguing that the right to bear arms should include automatic weapons. They've lost every single time. But what if everyone has been looking at this the wrong way? What if the problem isn't about gun rights at all, but about something much more basic? Whether Congress even had the power to pass this law in the first place. Here's the thing most people don't understand about federal law. Unlike state governments, which have broad police powers, the federal government can only do what the Constitution specifically allows it to do. Every federal law must be tied to one of Congress's enumerated powers in the Constitution. If there's no constitutional hook, the law is void. Period. When Congress wants to regulate something, it typically relies on one of two powers, the power to tax or the power to regulate interstate commerce. The National Firearms Act of 1934, which first regulated machine guns, used the taxing power. If you wanted a machine gun, you paid a tax, registered it, and you were legal. But the 1986 Hughes Amendment is different. It doesn't tax anything. In fact, the government refuses to accept tax payments for post-1986 machine guns. So there's no taxation justification. That leaves interstate commerce. Congress can regulate things that move across state lines or substantially affect interstate commerce. Sounds simple enough, right? Here's the problem. When you actually read the Hughes Amendment, it doesn't mention interstate commerce at all. Not once. Think about what this means. If you're prosecuted for having a post-1986 machine gun, the prosecutor doesn't have to prove the gun crossed state lines. They don't have to show any connection to interstate commerce. The jury instructions won't mention commerce. The law simply bans possession, full stop. This might seem like a technicality, but it's actually a fundamental constitutional issue. It's like if Congress passed a law saying everyone must wear blue shirts on Tuesdays. Even if that might be a good idea, Congress doesn't have the power to do it unless the Constitution specifically gives them that authority. Years ago, before he joined the Supreme Court, Samuel Alito wrote a blistering dissent about this exact issue in a case called United States v. Rybar. He pointed out that the machine gun ban lacks any connection to Congress's constitutional powers. At the time, his colleagues dismissed his concerns, but Alito had planted a seed that's now starting to grow.
All right, we've got this breaking news just coming into our newsroom right now.
It is unconstitutional.
Taken a few decades and a lot of work and a lot of talking, but it has finally bubbled up and people have finally taken notice at the highest levels of American law.
The statute criminalizes mere possession of a machine gun.
The Hughes Amendment is an unconstitutional ban that limits the rights of law-abiding citizens to own full auto firearms.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
Major breaking news as machine guns may actually be on the table.
Machine guns, are they back on the menu though? What does this mean? How did we get here? What happens next?
Fast forward to today. In their recent opinions, Judges Ho and Willett didn't mince words. Judge Willett wrote that the machine gun ban may be inconsistent with the Constitution's principle of enumerated powers. He noted that Congress has no power to enact a comprehensive criminal code, and that every federal statute must be based on one or more of Congress's powers enumerated in the Constitution. This is judge speak for Houston. We have a problem. Willett went even further, comparing the machine gun ban to a law the Supreme Court struck down in the famous Lopez case. In that case, the court said Congress couldn't ban guns in school zones without showing a connection to interstate commerce. The machine gun ban, Willett noted, has the same fatal flaw: no jurisdictional hook, no congressional findings about commerce, nothing. Judge Ho, meanwhile, explicitly stated he shares the federalism concerns about the law. When two judges of this caliber start raising these questions, people pay attention. So what happens next? The immediate case, Wilson's conviction, was upheld because lower courts are bound by precedent. But the judges made it crystal clear they think this issue needs to be revisited. They're essentially inviting someone to bring the right case at the right time. And here's where it gets really interesting. If this theory is correct, if the Hughes Amendment really is unconstitutional because Congress lacked the power to enact it, then the fix isn't simple. Congress can't just go back and add in interstate commerce to the law. The Supreme Court has made clear that post hoc attempts to fix jurisdictional problems don't work. Congress would have to pass an entirely new law, and in today's political climate, that's about as likely as finding a unicorn in your backyard. Which means if the courts strike down the Hughes Amendment on these grounds, post-1986 machine guns could become legal by default.
This issue was, of course, initially flagged by none other than Judge, now Justice Sam Alito.
All weapons that are bearable arms, even those that were not in existence at the founding, start off as being protected by the Second Amendment.
Gun rights are at the forefront of discussion today.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
922L's ban on machine guns built after 1986 is unconstitutional as it is currently written.
Not every instrument that is bearable will be protected by the Second Amendment.
Now, before anyone gets too excited, let's be clear about what would and wouldn't change. The National Firearms Act would still apply. You'd still need to register any machine gun, pay the tax, pass the background check, and wait for ATF approval. State laws banning machine guns would still be valid. This would only affect the federal ban on new manufacture. But for the first time in nearly 40 years, civilians could potentially buy newly made automatic weapons. The artificially inflated prices of pre-1986 machine guns, which can cost tens of thousands of dollars, would likely crash. The entire landscape of firearms ownership in America could shift dramatically. The timing of these judicial opinions is particularly significant. With potential Supreme Court vacancies on the horizon and judges like Ho and Willett on the short list for nomination, this issue could reach the highest court sooner than anyone expected. And remember, this wouldn't require overturning any Second Amendment precedent. This isn't about whether the Constitution protects machine guns as arms. It's about whether Congress followed the rules when they banned them. It's a procedural argument that even judges skeptical of gun rights might find persuasive. Justice Alito, who first raised these concerns decades ago, is still on the court. If given the chance to vindicate his Rybar dissent and strike down a law he's long believed to be unconstitutional, it's hard to imagine he'd pass it up. With the right case and the right timing, the votes could be there. Of course, this is all still theoretical. The wheels of justice turn slowly, and any case would need to work its way through the system. But for the first time in decades, there's a clear path forward that doesn't rely on expanding Second Amendment rights. The implications extend far beyond machine guns. If courts start seriously scrutinizing whether Congress has the constitutional authority to pass certain laws, it could affect everything from drug prohibition to environmental regulations. The principle at stake, that the federal government can only exercise powers specifically granted by the Constitution, is foundational to our entire system of government. Critics will undoubtedly argue that striking down the Hughes Amendment would endanger public safety. But supporters of the constitutional argument would counter that the ends don't justify the means. If we allow Congress to exceed its constitutional authority for good reasons, what's to stop them from exceeding it for bad ones? The debate also highlights the often overlooked importance of constitutional structure. While everyone focuses on the Bill of Rights, the Constitution's allocation of powers between federal and state governments is equally crucial for preserving liberty. As Judge Willett noted, these structural provisions are no less than the explicit prohibitions in the Bill of Rights, essential to the preservation of liberty.
The weapons unto themselves, they're not the problem. The problem is, what are you doing with the weapons?
922.0 lacks an interstate commerce connection or any connection whatsoever to Article 1 of the Constitution.
Even if you are innocent, your words can still be twisted and taken out of context.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
At the end of the day, there has been no machine gun ban, and the closest thing that comes to it at the federal level is the Hughes Amendment.
But any new machine gun built after 1986, you cannot possess as a general matter.
This developing story shows how a single legal theory, dismissed for years as a long shot, can suddenly gain momentum when the right judges take notice. It's a reminder that in law, as in life, conventional wisdom isn't always wisdom, and asking basic questions about government power can lead to surprising answers. Whether you support gun rights or gun control, this case raises fundamental questions about the rule of law and constitutional government that affect us all. Can Congress ban something simply because it wants to, or must it follow the Constitution's limits on federal power? The answer to that question could reshape American law in ways we're only beginning to understand. As this issue continues to develop, one thing is certain: the legal landscape around machine guns, stable for nearly 4 decades, is starting to shift. What seemed impossible just a few years ago now looks increasingly possible. And it all comes down to a simple question that should have been asked in 1986. Where exactly does the Constitution give Congress the power to do this? The federal judiciary is starting to ask that question. The answers they find could change everything. That's it for today, folks. See you in the next video.